Today I am going to talk about real property pre-sale agreements. A real property pre-sale agreement is a contract under which the seller and the buyer undertake to conclude a sales contract and execute the title transfer at a later date under certain conditions specified in the agreement. Pre-sale agreements are widely used especially in the sales of off-plan or under construction properties. The main obligation of the buyer is to pay the sales price, and the seller in return assumes the obligation to sell and transfer the ownership of a particular real property. The agreed upon price can be paid in advance or after the title transfer in a lump sum or in installments. A pre-sale agreement can be concluded before a land registry officer, and unlike a sales contract, it can also be concluded before a notary public. As a result, a pre-sales agreement which has not been concluded in presence of a notary public or a land registry officer shall not be valid and enforceable. As a rule, the seller and buyer can request the registration of the agreement into the land registry. The registration of the pre-sale agreement at the land registry shall be effective for 5 years. If a pre-sale agreement is registered at the land registry, the rights arising out of the agreement can be asserted against subsequent owners and right holders. If the property has been transferred to a third party in the absence of such registration, the buyer can only request the paid amount and the damages thereof from the seller. On the other hand, if the property is transferred to a third party despite the existence of registration, the buyer can claim its right of purchase against the third party. If the seller fails or refuses to execute the sales contract, even though the buyer fulfills his obligations according to the pre-sale agreement, the buyer is entitled to file a lawsuit to enforce the transfer of ownership. The pre-sale agreement ends with either successful execution of the sales contract or termination of the agreement by the parties. Termination of the contract must also be made at the notary just as the conclusion of the contract. If one of the parties fails to fulfill his obligations, the other party may give a notice for termination. Furthermore, the non-breaching party may claim his losses arising from the breach of the agreement. Foreign individuals and their family members can acquire Turkish citizenship by investing as low as $250,000 in real estate. Purchasing real estate on the basis of pre-sale agreements is a favorable option, permitting participants to apply for citizenship before they receive the ownership of property. There are some conditions that must be met to apply citizenship by concluding a pre-sale agreement. Firstly, at least $250,000 must be paid before the pre-sale agreement is signed. Secondly, there must be a construction, servitude or condominium regime on property. Thirdly, the pre-sale agreement must be registered at the land registry together with the undertaking not to assign or deregister the agreement for 3 years.